Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanti Reddy to discuss the latest updates on immigration, including the latest Department of Labor and USCIS new regulations, frequently asked questions, and we'll have a Q&A. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. I will start taking calls in 10 to 15 minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV News and agents are not responsible in any way for your actions. Use of this information at your own risk. Hi Prashanti Garu, how are you doing?
Hello, Andy. How are you, Ranjit?
I'm good. I'm good. I hope it has been a busy week with you with all the filings and all.
Yes, this month is going to be extremely busy.
Yeah. Before taking the calls, the news just got released today that DOL and USCIS new regulations, where Department of Labor regulations or rules takes effect starting tomorrow, that is October 8th, and USCIS regulations take effect starting December 6th, which is 60 days after the final regulation is published. Uh, could you please throw some brief summary on it?
Right. So this is a very far-reaching regulation. I mean, I guess we were expecting this, but we were hoping that it won't happen so quickly. I guess the reason that they wanted to implement it is because of the elections. So they want to implement it before the elections so that it'll have, the political impact that I guess they wanted to have. So there are two parts, as you said, to this regulation. One is an interim final rule, which basically means that the one part is effective immediately, which is the DOL part with reference to the wage levels. And the other part, which is the specialty occupation part, is going through the usual publication and comment period. So that will be effective after 60 days. And then after that, it will still be open for comments for 30 days. So the first part, which is the DOL regulation, we should talk about that first, because that's immediately effective. And this is also something we were expecting because it was in the list of regulations to be published even before. So what has happened is really they have increased the wage levels for all the wages. Pretty much, I was just looking at a sampling, and in New Jersey, a software engineer or software developer position is over 100K for level 2. And 75 or 78K for level 1 entry level, and this pretty much, I mean, at least not specifically, but approximately, it seems like level 3 has become that what was used to be level 3 has become now level 2 almost, and then so on and so forth, and then level 4 has become level 3. So they've jumped up one level basically. By just looking at the wages that they were there earlier and the wages that are there now. So this will result in litigation, let's hope first, so that if there's some unfairness in it, that can be resolved, because I think 1/3 of the applications, anybody who, like entry-level people who would previously file under level 2, will now be eliminated really, because entry level will have to start off, the salary will have to start off with 100K, especially in the New York, New Jersey areas. So and California and the metropolitan areas. This is going to eliminate 1/3 of the H1s immediately, unless they increase the wages, which means either lower profitability for the employers, for the small businesses that will be affected. It will only be small businesses that are affected. Simply because, the big firms anyway, their wage scales are more, and it's the small businesses that can't afford to pay, the higher salaries. So I'm thinking, and the MNCs also will be affected. But I'm more concerned about the small businesses. So because they have a very low margin of profit. So that'll eat into their profit, and they will either decide not to be in that business model anymore, so not to do consulting, if it's a consulting company, which means immediately several hundreds of thousands of people will be laid off, right, if they close their company. Or they'll slash their profits and try to continue, and then slowly move to maybe, a different model. So let's hope that there is litigation, and I believe that some, litigation is already being looked into because they were expecting this. So let's see what happens. This is something to be concerned about because it's effective immediately. Now, the second part, which is the specialty occupation part, in that part, they've really tried to reinstate through regulation everything that they were doing previously through practice, through policy memos. And they're not able to do that now because there was an ITServe versus Cessna. There was a lawsuit filed by ITServe, and ITServe won that lawsuit, as a result of which USCIS had to rescind a previous memo and issue a new memo, whereby a lot of the issues with consulting companies like right to control, employer-employee relationship, shorter duration of H1s, all those bad policy was pretty much rescinded. They were forced to rescind it because of the court order. Now it looks like via this regulation, they are trying to bring it back. So they're basically saying that if you're working at a third-party site, then you can get a H1 approval only for 1 year. They're saying that, and which they were doing in practice previously. Now they're just putting it in writing. The other thing they're saying is specialty occupation. So, for example, if your position requires a bachelor's degree in computer science, engineering, a few different fields, then they're saying it's not a specific specialty requirement, so it's not a specialty occupation. So, as per they're looking at the Occupational Outlook Handbook, which is available online, which is a publication of the Labor Department, and they're saying in that Occupational Outlook Handbook, if the requirement is not specific, which means just one major, if it's not just computer science, then any IT position will not qualify for a specialty occupation, and therefore will not qualify for a H1. And so they were already interpreting it that way, but I think now if they put a regulation in place, they will be more strict in interpreting it, and there'll be a lot more RFEs, etc., etc. So this is not good news at all. The only piece of good news about this is hopefully there will be litigation, number one. But remember, with specialty occupation, it's difficult to litigate because it's not very clear in the statute as to what is specialty occupation, whether, so it's an interpretation of the law. So the judge will have to disagree with that. And everybody agrees that, filing a lawsuit with reference to specialty occupation is always difficult. So let's see what happens. Also, it is not, will not be implemented, cannot be implemented until December. And we all know there's elections before that. A new government can be formed. And if that happens, and if the new government is more pro-immigration, pro-H1s, then, or at least fair, with reference to immigration, then maybe this will be rescinded. So it's too soon to tell. Definitely bad news, but we shouldn't lose all hope because two things. One is litigation might happen, and the second is, the government might change and maybe the regulations will be rescinded. Let's see what happens. Not sure. We'll wait and watch and see.
Yeah, true. Especially the concerning parties, as you said, the Department of Labor rule or regulation where, it's going to take effect starting tomorrow. So a lot of people now have confusion. So what happens? Is it going to impact the ones already working on H1B, or is it only going to be the new filings of LCA or PWD?
So if you have not filed the LCA, if you've already filed it, or, before it gets implemented, if you file the LCA, then there's no problem, but they've given us so little time that it's, impossible to file all the cases that you have within that period of time. So it'll, unless you file the LCA before it takes effect, it will affect you.
So the case is already pending, like, someone has an H1B already, which is let's say expiring in next 2 years, so they don't have to worry, right?
Correct, correct. Unless they file an amendment, then they'll have to worry
So
because
yeah,
you'll
so
have to file
new
a new
file.
LCA.
Okay, then new
Any new
LCA
LCA
file.
that requires to be filed. Then.
And I also heard that it's also going to affect the PWDs,
Yeah, so the prevailing wage, we only take a prevailing wage for green cards. We don't usually do it for H1s.
Yeah.
So any application that requires a prevailing wage, and the labor cert is one of them, that will be affected because again the prevailing wages. I mean that might not be affected as much because already they are giving prevailing wages of level 3 for most cases that we file. So I'm hoping at least they will give level 2 now because it's pretty much the same wage. I hope they don't continue to give level 3 and then it's 150,000 or something for the perm. So let's see how so basically the prevailing wage is decided by the Labor Department when you file a prevailing wage. You put in your job requirements, you put in your job title, you put in your duties, and then they will tell you that okay, they will choose the levels for you. You don't get to choose. So I'm hoping that they will choose level 2 because in the past they would always choose level 3. But if they choose level 3, then it's going to go up significantly. So let's see what happens. So which means that getting a green card will be more difficult because there's a question of ability to pay. So when you're filing the I-140, which is the second step, the employer has to show that he's either paying the prevailing wage already or he has the ability to pay the prevailing wage. So if he's paying already, it's fine, which is unlikely because, usually there's a discrepancy between the W-2 and the prevailing wage. Prevailing wage is always higher. But if he's paying, that's fine. But if he's not, then there'll be a bigger gap between the W-2 wage and the prevailing wage, and they have to justify that gap by showing profits in the tax returns. And often employers cannot do that because, as you know, they don't show too much profit because they, then they have to file more taxes. So they use the loopholes in the tax, in the IRS laws and, try to reduce their profits. So they show, so it's not common to show higher expenses. So then the I-140, higher profit. So the I-140 might get denied, which means pretty much your green card, gets denied in the second stage. So that's not a good thing.
Okay, that's a good information. So another question is, we know, people have to file LCAs and PWDs every now and then. And if this is going to affect starting tomorrow, is DOL going to update the website, that FLC data center or something, to reflect the new wages, or how is it going?
Yes, they've already done that. So they've said that as of tomorrow, they've already done it. So they've given a link to it, and they've said that if you file if you file today, then you can use the old wages. But if you file tomorrow, then you have to use the new wages. And that's why I was able to look and see what the prevailing wages will be from tomorrow for the New Jersey, New York area, and they have increased significantly.
Oh, good. Okay. Okay, we can discuss more, as things progress on this topic. But meanwhile, the other burning issue now is again, downgrades, I-140s, 485s, and all. A lot of people have a question is about I-944, which is a public charge form. There are instances where, some people say it's not necessary if you're filing it before October 12th. Some say it's mandatory even if it's not, if you don't have to send it after October 13th or whatever. Could you please explain about it? So is it necessary or, is it optional before October 12th, or how it works? Because I was reading a tweet from an attorney where, she was saying that, they got the petition back because they have not attached I-944, even though it's effective October 13th.
So yeah, so it's there. If you go to the USCIS website, there is instructions on filing and what to do. But basically, it's a little confusing for people who maybe don't practice law because their language is a little confusing. So basically, the language says that Before October 13th, if you don't send the 944 and supporting documents, then we will send you an RFE. But after October 13, if you don't send 944 and supporting documents, we will reject the case. That's what it says. So it leaves it to interpretation if for someone who is not reading it correctly. So that means if you don't send one bank statement, are they going to send the entire case back? So that, a lot of clients were calling today to find out, make sure that that's not the case. And that isn't the case. Again, I'm not answering your question, but I'm just answering another question first, and then we will get to your question. That isn't the case because there was a lot of panic today in my office as well, people calling. So that is not the case. The case, what they're saying is, you shouldn't take that language literally. What they're saying is if you don't submit the basic 944 form and the basic supporting documents, so at least something, credit score, something, at least one or two documents. I think mainly if you don't submit the 944 form, they will send it back after October 13th. If you don't submit the 944 form or the entire package before October 13th, then they will not reject the package and send the entire 485 and everything back, but they will send you an RFE. So that's how we have to interpret it. Right. So basically, there is some confusion on that, and I must tell you, there's confusion on the entire I-944 form, but because the instructions are not clear, but we have to get through this, and to file the 485 at this point. I'm just hoping that there'll be another injunction that can help us, but I think it's a little too late because as of now we do have to send out our cases by October 31st. Unless the new November visa bulletin shows availability in November as well. But we will not know that until maybe October 15th or 20th. So as of now, we have to prepare everything as if, we are sending out on the 31st. So there's no room for error or, guesswork. So pretty much we are sending out the 944 application with all the required documents.
The other question about 944, a lot of people were asking is, so is 944 for every applicant on the file? Like, let's say if husband and wife and also two kids are filing, so do you have to fill it for each and everyone?
Yes, unless you fall under one of the exceptions, and they're very limited exceptions like asylees, VAWA cases, violence against women cases. Unless you fall under one of the exceptions that is mentioned, you have to fill it for each and every person, whether it's a minor or an adult. So if you have a family of 4 filing, like husband, wife, and 2 children, you'll have to send out 4 944 applications with each 485 application.
So how about a kid who is a US citizen? So are they still be included in
a child who is a US citizen will not have a 485 because he doesn't require it. He's a citizen. So in that instance, if there's one child who's a US citizen, one child who is not, then you will file 3 cases, right? Husband, wife, and then the child.
So what information for kids to be included, especially, kids and spouses may not have credit reports, they may not have any assets or bank balances, or, they may not have a lot of other things. So are those fields or whatever the documents to be left empty?
So rule of thumb, don't leave anything empty. Either say none or say not applicable, but do not leave it empty, because we've seen instances where 485s have been returned because a column is left empty, and that's, they shouldn't be doing that if it's not applicable. But unfortunately, if they do it, there's nothing you can do, because if the case comes back in December, for example, or in November, and the visa bulletin is no longer current, that person has lost his opportunity to, file the green card. So don't leave any column empty. But just to stress on the basic information needed for a 944, the first thing is they look at the household income. So if the household income is 125 percentile of the over the poverty guidelines, for example, approximately, it's not much for a family of 4, maybe 25,000. If that's the case, if it's above, then we really don't have to worry about the case getting denied, but you do have to send supporting documents because they want it to be above the 250 percentile. So, and most cases are, especially employment-based cases, and for the technology people, because they, definitely get paid more than that. So they might just, most of them, 99.99% will just qualify based on their income. But for whatever reason, USCIS wants to see for the 944 other public charge documentation. They want to see this credit report, they want to see health insurance, and they want to make then a decision based on all that. So if you just say that they're already meeting it, we don't have to submit any additional documents, that I don't think that's going to work. So what we are doing in our office is pretty much, submitting everything, and also including, there is one part 9 of the 944, which talks about the assets and the liabilities. And it's almost like filling out a mortgage application. So they want to see the cash value of, if you have any property or house, they want to see the cash value of the house, which is basically market value minus the mortgage that you took. So that will be your asset. The difference, that is going to be the asset. And they're going to look at, for example, if you have 2 cars, then you can include one of the cars as an asset. Again, you do the same thing. It's a net asset, which means that you take out the mortgage that you owe for it, and then you do an assessment of what the present value is, and then the difference is basically the cash value of that property. So there's a column, you have to add everything together, and then there's a column for liabilities, so your mortgage, whatever other liabilities, the car loan that you took, whatever else you have. They want obviously the assets to be more than the liabilities. So, whatever information you put in there, you have to submit supporting documents. Otherwise, you cannot put that information. If you're putting your house information as an asset, then you have to show the appraisal for the house. You have to show the mortgage documents. So that's what it is within 944. So it's very burdensome and onerous, because it's hundreds of pages that have to be printed out and submitted, including the tax returns. So each application is like several hundred pages long. It's such a waste of paper, really. And I don't see any purpose in the 944 if you're working and you have a good salary and you're above the poverty guidelines. I don't see a purpose. They're just trying to make it more difficult, because those people already, I understand they're asking for health insurance and, asking for your credit score, but I don't understand why they need all the assets and liabilities if your income is already above, what is required.
True. Hope things change, there was an injunction earlier and they again took it back. So probably something should come.
And they're also asking for dependents to submit their educational credentials.
Is it?
Mainly the adults. The children don't have to. The children will just piggyback on, all the assets and the liabilities of the parent. So we just have to duplicate the process for the children, because they don't have any assets of their own, obviously. They don't have an income of their own. But if the spouse has an additional income, is also working or has property, you can use that as well. And you should submit that in the spouse's form and, submit the additional documents.
Okay. So if, let's say, spouses have a degree or something, they have to do an evaluation, or they just submit that degree, whatever they have?
They have not. Why again spend money on doing an evaluation? They have not asked for an evaluation.
So they just have
if
to include
they think it's needed, they'll ask for it, then we can submit it. But again,
Okay.
because already the income is reaching that level, they will do an assessment, but, I don't think it's critical, all this information. So, I wouldn't be too nitpicky on it. I would submit it, but, not go overboard with it.
Got it. Another thing a lot of people have in mind is, let's say if they don't have enough, most of people would have, let's say hypothetically, some doesn't have enough income or assets or whatever for the reasons. So can they include property or money from back in India?
Yes, they can, but then they have to provide all the documentation for that. Any property that is on their name, they can include. Anything that they can sell within 12 months, they've clearly said is you can include it. Movable property. Like if you have an asset of maybe a bank deposit which you can't take out for more than 12 months, then you can't include that as an asset. So yeah, property in India, as long as you show the appraisal and you show what the loan is on it, if there is any loan.
Probably they have to also show the conversion into dollars, maybe.
Yeah, or we can let USCIS do some work and figure it out for themselves.
I hope it's that easy. Okay, yeah. The next question, other people have is now everyone is piling up and filing the 485 applications, and so what happens? Can they travel while the 485 is pending? Because there are lot of things happening around the world, and what if there is an emergency and they have to leave the country? Is it okay once they get the receipt? Can they travel?
Yes, so a lot of people have. It is true because there are many of my clients whose things have happened, their parents have passed away and they want to travel, or in-laws, or whatever the reason might be. There are quite a few people in that situation. And at the same time, they are scared because, this is a lifetime opportunity, so they have to file and they don't want to do anything to jeopardize their status. So it has been, somewhat controversial because in the past, if you were on a H1, you didn't really have to travel on advance parole. You could just travel on your H1, come back, and your 485 is still valid. Then there was some talk about, that being a problem, and how usually for family-based cases only it's a problem. I'm not talking about employment-based cases or dependents, but if you're filing like an I-130, your spouse is filing for you, whose spouse is a US citizen is filing for you, or you are a US citizen, you're filing for your parent, that's a family-based case. And for those cases, if you file, you cannot leave the country until the advance parole is approved. And if you leave the country, then no matter what your status, and if you come back on even if you have another visa, your 485 is gone. You are considered to have abandoned your 485 status. But that is not so for employment-based cases. Employment-based cases, the unique thing is that even you can choose. You can either travel on your H1 or your H4 or whatever your non-immigrant visa status is, or you can choose to travel on advance parole. The only thing is that if you apply for advance parole and then you leave, your advance parole application may not be processed. They may consider it to be abandoned. But so as long as make sure you have some kind of a visa that you can come back on, if you're traveling after, you file your 485.
So got it. So there is little risk involved, but if you have to, then you have to. And probably, as you said, if they reject the I-131 application, the advance parole, they can probably file it back again, right?
Right. They can file it, come back into the country when they have time and file it then. Because there's also biometrics required. So if they're out of the country, they won't be able to take those biometrics. So yeah, there's complications for the I-131. But as I said, if they have other ways to return, if they have a valid visa on their non-immigrant status, then they can return using that.
So other thing, a lot of people are telling is now, if let's say the kids under 21 who are on F1 and filing an I-485 for them, F1 has a different intent of visa, which is non-immigrant, unlike H1B, which is a dual intent. So how does that scenario work? Can they file, what happens to F1, what happens to 485?
Well, for children who are not going to age out, it's fine because they pretty much will not be on an F1. What will happen is they'll file a 485, they'll file for an EAD, and based on that 485 EAD, they will go to school. So they will not be in F1 status, they'll be pending 485 status. But then what will happen is if they age out, then they will fall out of status because they have no other status.
Okay, sorry to stop you, Prashanti. We have a caller. Looks like Sumit Shekhar from New Jersey. Let's take the call and then we can resume the discussion. Hi, Shekhar. Welcome to the show. You are on the air. You can ask your question.
Hi, good evening. This is Sumit. So, my question or my thought process is revolving around the new changes that are coming in, and I'm not sure if this question has been asked earlier, but predominantly, what are the key takeaways, from this new changes that are coming in, and if so, are there any injunctions that are expected to come in, because I am seeing these mixed responses from different law firms that, just the way the previous, executive orders or stuff like that were challenged in the court, these new proclamations that have come in the last 2 days will also be challenged. And then what will be the overall impact on the people who are on H-1B or other work visa?
Yeah, so as we were discussing, I think for sure that it will be challenged, and already some law firms and AILA, I'm sure, is looking at challenging both parts of this regulation, the wage part as well as the specialty occupation part. The wage part strongly so because the wage has been done based on interim final regulation without any comment or publication period. And when you do that, as per instructions, you have to have a very strong reason for not going through a regular publication period and comment period. It has to be of such vital importance that you have to be able to justify that. So whenever there is an interim regulation, it's very ripe for litigation, because you have to really show an immediate reason, like something that cannot wait. So, and usually an economic reason is not a good reason. So first of all, it is difficult to show any reason for this interim regulation, because if you look at the unemployment if you look at who's using H1s, 80% of it is IT companies, right? And if you look at the unemployment rate in that industry, it is minimum. In fact, it has decreased during the COVID period. So there is no justification for it. And the second thing is that anyway, an economic justification is never a good justification, and the courts will, immediately strike it down. So I think I think it's a good case, this interim final regulation, it's a good case for litigation. And in addition to that, with reference to the specialty occupation and this right to control and everything they're trying to bring back through regulation again, is again, I think, a good case for litigation, because already it has been struck down once. Because, they're saying that it is not it's not, according to what the law was meant to be. So I'm hoping that even though there's a regulation now which makes it stronger, of course, and they have more justification for implementing it, the courts will think that, I hope the courts will find it ultra virus, because they have to basically look at the law, and if it is against the actual law, then they might strike it down. So we have to wait and see, I think. And also, as I was saying, politics plays a role, and with the upcoming elections, and if there's a new administration, then things will change, because a lot of things are being done for election purposes also. So let's see what will happen, but definitely not good news. But it's not the end of everything, because we have hope because of litigation and also the political scenario changing. How it will affect? It will definitely affect, because the wage levels are changing. So employers will be forced to pay higher wages, which is a good thing. But if they're able to afford it, they will. But if they're not able to afford it, then they will just lay off people en masse, and it will be difficult for students.
Right. Yeah,
it's difficult for students, right?
Absolutely. Yeah. Ma'am, again, there are two sides to it, right? One is obviously the ability to pay. The other one is, ability to garner such wages, in this kind of a mixed kind of an economy, right? The base
Yeah,
for this rule does not even stand, right? I'm not sure if the people who
right.
are in the policy making and strategy on the USCIS DHS side are actually really looking at the data that they have in front of them. Complimenting or just saying that American workers are not being hit because of low wage people in H1. I think they're it sounds like as if H1B is a lot of a debate, and we are being looked down upon for some reason. Whereas in reality, we are not doing anything different than what other U.S. workers are doing, right? I mean, we are executing contracts. We are at the best of our ability when we execute the contracts, right? And we have the right backing, the right knowledge, and we are able to, kind of get the support from the organization wherever we work, right? So all these things are, in my mind, there's no base.
Right. So it's also a lot of it is not USCIS making the regulation. It's coming from the White House, So it's based on an executive order that Trump issued in the summer. So it's based on that purely, and it's a lot of politics involved. And what has happened is they've taken one case, like the Disney example, and they keep on repeating that and bringing that up and say, oh, look, in this case this happened, there was this fraud. Yes, anywhere, anytime there is a law, there will be fraud, but that doesn't mean the fraud is so prevalent or it happens every time. So you have to look into that and really see what the wages of these people are, whether they're commensurate with wages that are being paid to non-H1 workers. Often they're either the same or in fact they're more, because there's a requirement, they have to pay a certain wage. So oftentimes you see that the wage paid to H1 workers is actually more than the wage being paid to non-H1 workers. So, and then which brings about a disparity, and again is against labor laws. Either way is not good. So I think a few bad apples in a few cases being highlighted, and then they keep on saying there's so much fraud and the wages are so low. That is not the reality. And also, I mean, what's going to happen? The other effect is that all these jobs finally are going to go out of the country. And other countries like India and Mexico and European countries will benefit from it, and they're already benefiting from it. But what happens to the US economy then? Don't we care about the US economy? Don't we care about the tax revenues that these well-to-do immigrants generate, and the businesses that they are opening? And if you look at the CEOs of all the top companies, you'll see they're all first generation South Asians who have come on H1 themselves, including Elon Musk. So so that rhetoric is lost. It's all politics, and short-sightedness, and so it's not based on facts.
So now the final. There's nobody in this world who can kind of predict what's going to happen in future. But do you predict that these difficult situations are going to stay the way they are? Because election is coming. We don't know who's gonna take the center stage. But even given that there are people who are pro and against immigration on both sides of the house, right? So where do you think from a H1B or work visa people, where do you think we are in an overall picture? Are our rights being violated, or are they taking very difficult measures? What are your thought process overall, Madam Reddy?
Right. So so the problem with what happens is, when there's a regulation that is put in place, it takes time. Even if there's a new administration, And even if they want to make changes, it takes time for those changes to happen. They don't happen overnight. So I'm very concerned about, a regulation becoming final. And if the court doesn't strike it down, I think it's going to stay for a while, because the new administration has so many other priorities. It's not just one thing. So by the time they get to it, or by the time they, decide to rescind it, again publication, again comment period, it's going to take a while. So I'm hoping we don't have to go through that, and I'm hoping that it'll be nipped in the bud, by the courts. That's the best scenario that we have. So let's see what happens.
So in this period, would you have any guidance for people who are on work visa? That would be my final question. I'm so sorry.
No, it's okay. But if you're already on a H1, and if you're already working, as long as you don't file an amendment, or you don't have to file an extension, you're not affected. But if you do have to file an extension or amendment, then you will have to pay the higher of the salary. So you'll have to talk to your employer and see if, what your salary is versus, what your hourly rate is versus what the salary is, and if it's making sense. And that's going to decide everything, really. I mean, for green cards, we don't have maybe think about it right now, because, unless, of course, your H1 6 years is expiring, then you're forced to file the green card. But at least we have a little bit more time. A H1, you will have to file it immediately, and it's something that will affect you immediately, I think. So I think we'll have to wait and watch, and you'll have to have a discussion with your employer before, see when your extension is due, or before you decide to change jobs. You have to rethink that right now.
Yeah, Prashanti, so anyways, this is going to take effective tomorrow. So the question now is, the courts take some time, I believe, at least few days, few weeks, or whatever. So until that time, I believe few people will be affected anyways. So
yes, that's inevitable. Whoever is filing now and has to file now, because either they're joining a new job, and they can't join a new job unless the LC is filed, or if they're filing an extension and they can't wait to file an extension because the I-94 is expiring. So if you can wait, just wait. I think you shouldn't file now. Just wait if you have time for the extension, because we also have premium processing. So you don't have to file 6 months ahead of time. So that's one suggestion. If you don't need to file the extension now, wait and see what happens. If you don't need to, if you're making a decision to change your work site, change the client, and you're going outside the metropolitan statistical area, and you need to file an amendment, try to see if you can stay in the same job, at least for now, especially if the salary is not conducive. Because rather than falling out of status, it's better to stay where you are.
true.
Or another way, Ranjit, is to change to H4 EAD, then there is no prevailing wage issue. Or to file a 485 in October, hopefully, and then there will not be any prevailing wage issue.
People who are filing downgrades or 485s now probably would be kind of okay. If you have H1B for, let's say, an year or so, and then, you're filing 485, by the time your H1B is expired, you would get an EAD, and I don't think you will fall under those restrictions of having, paid the prevailing wage on the levels. So that's one thing. So yeah, let's see what's going to happen. And going back to previous question, we are talking about the kids who are going to age out, and who are a part of I-485, when they have the pending I-485, which has a different intent, and F1 has a different intent. So how is it going to affect their visa?
Yeah, so if they're going to be aging out, I mean, if they're on F1, it's an issue. You cannot have both statuses. But if you're on a H4 dependent, then it's fine. You can maintain your H4 and maintain your 485 at the same time. You don't have to choose. You can do both. But if you're on F1, you have to choose immediately. So you'll have to file your 485. And then if you have to travel, you cannot travel on F1. If you have to change schools, you cannot change. Because anything that requires a I-539 form to be filled out again, or any time you're re-entering into the country, on an F1 you will have trouble. If you're not doing any of those, then you might not have any trouble, as long as you don't have to approach the USCIS or CBP for anything. So automatically you don't fall out of status. It's only when you approach them and you have to fill out the form or you travel that you will encounter, the dual intent issue. So they may not allow you back into the country. They may not approve your I-539, whatever you're filing for. So that could be an issue. But this aging out as it is, it's not, the issue has not been caused by the October visa bulletin. It has made it better because these people have already aged out or going to. So at least it's allowing some people to benefit, but not all, depending on the timing of it, right? So, just with reference to aging out, if your dates are current as per the final action dates, in the visa bulletin, we have two tables, right? Final action and dates for filing. Final action is actually your visa number becoming current. So if that is happening, which is not happening now in October, then you will not age out. Your child will not age out because as soon as you file the 485, your child's age freezes automatically. But unfortunately, this October visa bulletin, a lot of people are filing based on dates of filing. So that's an artificial thing created by USCIS. Your dates are not actually current, but they're allowing you to file in advance. So when that happens, then, your children will age out, and filing the 485 does not freeze their age.
Yeah, sorry to interrupt you, Prashanti. We have a caller, Sham Kishore from California. Let's take the call and then we can continue. Hi, Kishore, you are on the air. Please ask your question.
Okay. Hello, Prashanti. How are you?
Hello, Andy. Good, thanks.
Yeah. I have a question. You already addressed this issue, but regarding the 944, do we need the entire credit report or just the score? And children, you say do we have to add the assets for both the parents? Because my wife is also working. She's working on H4 EAD, and I'm trying to downgrade to EB3 because my priority date is 2013 June.
Yeah, so I-944 has to be filled out for each person. If your wife has separate assets and not joint assets, separate from you, then you have to include that in her 944 and submit those documents accordingly. Anything joint on both your names will be useful for both of you as well as your children. For the children, they don't have anything of their own, so their parents' assets have to be shown. So yeah, that's. You had another question? Other than that, you were saying something else?
Okay, do we have to add both the parents' assets for the children? Because she don't have a social security number, so she don't have any credit of her own.
Yeah, so for the children, you will have to add the total assets, which is both parents' assets and the total household income.
Okay, Prashanti. Thank you, madam.
You're welcome. Good luck.
Yeah, so coming back to our previous question, so now we are talking about the kids who are going to age out, let's say in a year or two. Now anyways, they are going to file a 485 and using the filing dates, and let's say final action date becomes current, as you said, there anyways the age gets logged. But in such cases where it's not getting current and they have to move to another visa status, obviously they have to apply a F1 visa. So that's the
then they have to withdraw then they have to withdraw their 485 application.
Okay.
And then they have to file for an F1. They will have to do in that instance is leave the country and come back on a F1 status, F1 visa. Because once you're on 485, you cannot file change of status. If you're in adjustment of status, if you have an adjustment of status, you cannot change that to another status. You will have to withdraw, leave the country and file for a fresh F1 and come back in. And that's a big problem because with their family members all with having a 485, there's definitely an intent.
Yeah, true.
So and it is an issue, but
it is what it is. At least there are a couple of lawsuits pending on it. So let's hope at least the court decides what to do, or let's say the final action date becomes current, or some.
So the only thing that will be deducted from their age is the time that it takes for the I-140 to be filed. for the
Yeah.
I-140 processing time, which is not
So
much
let's-
because everybody does premium processing nowadays.
Yeah. Let's say if they are filing a downgrade, then it will at least be pending for few months.
Maybe 6 months, maybe.
6 months or 1 year or whatever the period
Yeah,
that could
so that yeah.
extended for as a CSPA.
Maybe you shouldn't do premium processing then. I mean, even if you can, which you can't.
True,
but even
especially if you
can,
have older kids.
aging out children, yeah, you shouldn't.
Yeah, we have a caller. Let's take the call. Sam from North Carolina. You are on the air. Please go ahead and ask your question.
Yeah, good evening. Thank you for this information. My question is on the, I would like you to please, if you can shed more light on the specialty of occupation as related to the PAM application. Currently, my PAM application has been filed since May 2020. So I want to know if this is going to impact the current one that has been filed already. So I just want to understand the specialty occupation as related to the PAM application.
So specialty occupation does not relate to your PERM application in any way, because that's a concept which is restricted only to the H1s. If you're filing a PERM application, they don't care about specialty occupation. And the increase in the wages does not affect you because you've already filed a prevailing wage application. So it doesn't affect you really. It'll only affect you when, if you have to file an extension of your H1, or you have to file a transfer or an amendment of your H1, that's when it'll affect you. I don't think it doesn't affect your PERM application.
Oh, okay. Thank you so much.
You're welcome.
Okay, that answers the question. And the other thing a lot of people now are looking for is the birth certificate, name changes, whatnot, a lot of things going on. So one question a lot of people have is, do they have to submit the originals, or, only the copies would work, because a lot of people have to get from other countries?
They only ask for copies. They don't, if they need originals, then they will ask for them and then they will return them, or they will look at them if there is an interview, but usually they only ask for copies. So we only submit copies. We don't submit originals.
So yeah, so everyone don't worry about it. At least for now, just get the copies and submit them. That would
keep the originals with you in case they ask for it. Then we can submit it.
Yeah, they can get it mailed and keep it with them ready. And the other question is, unlike the H4 EAD where you cannot work when the renewal is pending. So can you? I believe I-485 EAD, when it's pending, I mean not the initial one, but the renewal. When the renewal is pending, you could work for 6 months. Am I right? Could you please explain about it?
Not as far as I know. If you have a 485 EAD and the EAD has expired, you pretty much have to stop working.
I mean, when renewal is in process, what I mean is.
Yeah, but you don't have an EAD at that point unless the EAD has not expired. I mean, they wanted to make that change, and there was a lot of talk about making it, but I don't think they actually did. So as far as I know, if your EAD has expired, then you cannot work. That's why people are in such a rush. Everybody files their even 485 EADs like 6 months in advance, as soon as they can file it, because it's taking so long for the EADs to come through. It's the same with H4 EADs as well.
Okay.
So yeah, I would file it as soon as possible.
Okay, I have heard that you can work when it's pending for 180 days, something like that. Okay, maybe I'm wrong, I don't know, but yeah, that's what I've been hearing. People are discussing about pros and cons of filing the 485s and EADs and whatnot, everything, and that's something everyone was discussing. Is
I mean, there's no harm in filing an EAD. I think you should, and then you can decide whether you might need it in an emergency. So I think you should file it in case something happens with your H1, or you're not able to file an amendment, or because of these wage levels becoming skyrocketing. I think there is no doubt about the fact that you should file if you plan to work or if you're already working, I think you should file for your EAD.
Yeah. Another question a lot of people have is, for a lot of reasons, probably few people may not be able to include their spouses now. Maybe because they are not in here, they are in India, or few people they don't want to do, or for whatever the reasons. Let's say they are not filing the dependents for now, and at what point of time can they add the dependents? Again, the dates have to be current for the filing dates or the final action dates, and USCIS have to accept it, or they can add it any point of time.
They can't add at any point of time. The dates have to be current again for them to add their spouses, unfortunately. So this is the opportunity to do that. If you lose this opportunity, then you'll have to wait until the next opportunity comes by.
Okay. Another question here is, I know a lot of people, it's an optional to file I-485 along with, I-131, the advance parole and EAD. If you file together, there is only one fee. Let's say if they don't want to file EAD and advance parole now, and if they want to file it later, do they have to pay the fee for the EAD and AP separate?
Yeah, so as per, again, because of the court has again saved us, because the fee increase was supposed to be implemented, right, as of October 2nd, but there was an injunction against it. And as per that new law, there was a separate fee for every application. So you had, $588. So you had to pay like $1,000 more if you filed the EAD and I-131 advance parole. But now, since that new fee increase has not been implemented, as per the old law, there's only one fee. If you're filing with the 485, you don't have to pay anything extra for the EAD and advance parole. So you might as well file it because you're not paying anything extra. But if you choose not to and then you need to file it later, then yes, another $1,000, $500 odd for each application to file later. Plus the attorney fee, because the attorneys will again charge for it if you're not filing it with the initial application.
Okay. Other question a lot of people have is there anything called self-filing? Because a lot of people are saying a lot of things, if let's say the old employer is not supporting in any way, can they file it themselves directly through an attorney, or, an employer and the information or signatures or whatever are needed from an employer?
You cannot file a 485 without the 485J, which is the offer of permanent employment, which means that it is an employment-based green card. It's not a family-based green card. You don't have a family member supporting you or filing for you. Your employer is filing for you. So obviously there has to be an employer. So previously we would file the 485 with an employment letter, offer of employment. Now the 485J has taken the place of the employment letter. So yes, you need an employer. You need to sign off on the 485J. You need to work for that employer at some point. It cannot be, just an offer of employment without you actually working for that employer, because then you won't get a green card.
Got it. So I think we reached towards the end of the show. Again, if anyone has, any consultation needed, private consultation, or, any help with 485 filing or anything, please reach Attorney Prashanthi Garu for private consultations at 212-354-1010 or prashanthi@reddyesq.com. Again, thanks Prashanthi Garu. Thanks for your time. Thanks for all the calls and watching the show. It was a great session with interesting topics. Please call in every Wednesday at 6 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 6 p.m. EST and Sakshi TV. This is Ranjit signing off. Thanks, Prashanthi Garu. Have a good day.